Good morning. Welcome to the Society of Wetland Scientists webinar series. We are glad you could join us today. My name is Jody Burns, and as co-chair of the SWS webinar series planning committee, along with being a PWS certified private consultant, I am super excited to be the moderator for today's webinar. Our webinar series planning committee is excited to share this SWS e-learning experience today for our members to stay connected virtually and to assist you in earning continuing education credits. Today's lecture and topic will be Sackett versus U.S. Environmental Protection Agency, implications for WOTUS and the Clean Water Act. As a longtime fan, it is my distinct pleasure to introduce our speaker today, Professor Royal C. Gardner. Royal Gardner is a professor of law and director of the Institute for Biodiversity Law and Policy at Stetson University College of Law in Gulfport, Florida. He has worked on wetland law and policy issues for more than 3 decades, beginning, oddly enough, at the Pentagon. He has co-authored amici briefs, which are a legal document supplied to a court of law containing advice or information relating to a case from a person or organization that is not directly involved in the case. That's an aside. We want to make sure everyone understands what amici briefs are. So he has co-authored them on behalf of environmental scientists and scientific societies in Clean Water Act cases, including as lead counsel for the amici brief filed on behalf of SWS and other scientific societies in the U.S. Supreme Court in the cases of County of Maui versus Hawaii Wildlife Fund and the Sackett versus EPA case currently. He is also the author of Lawyers, Swamps, and Money, U.S. Wetland Law, Policy, and Politics, which has a small cult following. Please take it away, Professor Gardner.
Thanks so much, Jody, and thanks for the kind introduction, and thank you to SWS for inviting me to join you. I'm going to share my screen. All right. So I'll be talking about the Sackett case, but in order to do so, I have to give quite a bit of background and context. And so here I am. Actually, I'm standing in a wetland, a cypress dome in the Western Everglades, in Big Cypress National Preserve. And so, a question might be: is this a WOTUS? Well, it depends on the definition. And for those of you who are practicing in the area, you know that the definition is frequently in flux. And currently, it depends on which state you're in. So in about half the states, the newest rule, the 2023 Waters of the U.S. rule promulgated by the Biden administration, is in force. But in about in 26 states, that rule has been enjoined by litigation, and thus the pre-2015 regime applies. So before we begin, I'd like to see if we can do a quick poll here to get your views on the difference between the 2023 WOTUS rule and the pre-2015 regime, if you have an opinion on this. And so there are a lot of choices there, but essentially, we'd like to know whether you think it increases or decreases Clean Water Act jurisdiction, either significantly, moderately, or slightly. And then there are 2 other choices, that it, in some cases, slightly increases it and slightly decreases it in other cases, or there's no practical difference between the 2. So we'll give you a few more seconds on that to choose. All right, thanks for playing. So let's see what the answers are. We've got 7% saying that it significantly increases. We've got 17 saying moderately, 29% with slightly, So 20% will say that there's no practical difference. 21% slight increase and slight decrease. And then a little bit more. Okay, so interesting. So there's quite a bit of a range there. Really from moderate increase at 17%, slight increase at 29%, slight increase and or decrease at 21%, and then 20% saying no practical difference. So that's very interesting. And if you don't mind, if you can post in the chat examples of where you think jurisdiction has either increased or decreased because of the 2023 rule. All right, so with that, let's see, let's move on here. Okay, so what I'm going to do in the time that we have is give you a little context, a little history and background, walk through some of the litigation and rulemaking that has taken place, and then get to the main event, which is talking about Sackett versus U.S. Environmental Protection Agency, and then the possible outcomes and implications of that case currently pending before the U.S. Supreme Court. So quick review of American government, because WOTUS actually implicates basic foundational issues. So obviously the question of what is law, who gets to say what the law is? Well, it begins with Congress enacting a statute or passing bills for the president's signature. But often those statutes that Congress enacts are ambiguous, or there are gaps, and they need to be interpreted. So then the question becomes, who interprets it? Typically, an agency, an executive branch agency like the EPA or the U.S. Army Corps of Engineers will interpret the law, and then it may be challenged in court. And the question there is, to what extent do the courts grant deference to those agencies? And that is a subject of continuing debate. So ultimately, it's Congress that gets to tell us what the law is, but how is it interpreted after Congress writes these laws? If it gets into the judicial branch, typically the trials will start at the U.S. District Court, and then they're appealed to the U.S. Courts of Appeals, and then ultimately perhaps the Supreme Court will take the case. One of the interesting issues at play in WOTUS and in other contexts as well is, what is the authority of a single U.S. District Court? Can a single U.S. District Court in Texas, say, issue a nationwide injunction, issue a ruling that applies throughout the country and not just within its own judicial jurisdiction? And then, of course, underlying all of these issues is the concept of federalism and the relationship between the federal government and the state governments. And so we'll talk a little bit about all of these throughout the course of this presentation. So to start with, why does the federal government have the authority to regulate streams and wetlands? Well, in theory, the federal government is a government of enumerated powers. So you have to point to something that is in the Constitution. And typically it's the Interstate Commerce Clause that the feds rely on for environmental purposes. The Clean Water Act, as we will talk about, covers navigable waters, which is defined as waters of the United States. What does that mean? Well, the EPA and the Corps then try to answer that question, fill in the gaps by issuing a regulation. And that regulation has to go through a public notice and comment process. So the proposed rule is published in the Federal Register, which gives notice to the public and interested stakeholders. Everyone has an opportunity to provide comments on the proposed rule. The agencies then must consider those comments before publishing the final rule. So those regulations actually have the force of law. They're supplemented, as many of you are no doubt aware, with guidance documents, including technical and scientific documents such as delineation manuals. So it's one thing to say, okay, here's the regulatory definition of waters of the United States that includes certain adjacent wetlands, and you have a regulatory definition of wetlands, which is a paragraph long. But what do you do in the field? What are the specific hydrophytic species? What are the hydric soils that need to be present? Well, these are found not in the law as a statute, not in the regulations, but rather in what we would call guidance documents that do not have the force of law, but are very, very important in explaining how the agency will be exercising their discretion in applying the law to a particular set of facts. The Corps of Engineers has had a regulatory program since the 1890s under the Rivers and Harbors Act. And here, the Corps of Engineers regulated activities that might interfere with navigation. And so this is where we find our traditional notions of navigable waters. These would be waters that are navigable in fact, they're actually used in commerce. There is also the concept of once navigable, always navigable. So if they were navigable in the past, they are considered to be a traditional navigable water, as is the case with almost navigable waters, waters that might be navigable in the future with reasonable improvements, and then anything subject to the ebb and flow of the tide has also traditionally been considered a traditional navigable water. So in terms of, okay, what did that cover? You've got the territorial sea, you've got a river, you've got coastal wetlands. These would be your traditional navigable waters. Water quality issues were largely left to the states at that point until 1972, when we had Congress enacting the Clean Water Act, actually over President Nixon's veto. It's always fascinating to me that this law was enacted in 1972, 1 month before Nixon had a landslide re-election. It's amazing because here you have Congress actually overriding the president, who is about to have this massive re-election win, but also that they're actually still legislating just 1 month before the election. In any event, this set up a new framework, and it prohibited discharge of pollutants from a point source to navigable waters. Except here, Congress defined navigable waters as waters of the United States. What does that mean? Well, initially, the Corps of Engineers said, well, we know what navigable waters are. We've been regulating navigable waters since the 1890s. Traditional notions of navigability. This brought one of the first WOTUS suits by environmental group NRDC versus Secretary of the Army Callaway, and the court, it was a district court, trial level court in DC, said, Congress intended for the agencies to regulate to the fullest extent permitted by the Commerce Clause. So the Corps and EPA should be regulating beyond these traditional notions of navigability. This then led the agencies to go through a series of rulemakings, ultimately culminating in 1986, 1988, to where you see all of these areas were subject to jurisdiction under the Clean Water Act. Isolated waters up there in the top of the center, they would be covered to the extent the use or degradation of those waters affected interstate commerce. So then the regulated community then brought suit and challenged this as going too far. And so it led to 3 cases before the U.S. Supreme Court. And the first was Riverside Bayview Homes in 1985. And this dealt with wetlands that were adjacent to a traditional navigable water. And here the court ruled 9-0. It was unanimous that it was reasonable for the Corps of Engineers to assert jurisdiction over these adjacent wetlands because of their connection to traditional navigable waters. For example, with respect to the water quality functions that wetlands might provide to a traditional navigable water. So deference to the agencies in that particular case. That was followed 15 years later in a case called Swank, Solid Waste Agency of Northern Cook County, which dealt with the so-called isolated wetlands or isolated waters. And here the court ruled that the Corps of Engineers had gone too far, that it was unreasonable to assert jurisdiction over these isolated waters, at least to the extent that the Corps was trying to do so in this case, based on the presence of migratory birds. Part of the reasoning for the Supreme Court was that for the federal government to regulate these waters that had no direct hydrologic connection with a traditional navigable water was infringing on areas that were traditionally left to the states. And so there was some federalism concern there. And so in that case, the Supreme Court declined to defer to the agencies. And that was a 5-4 decision. And then we come to Rapanos in 2006. So this dealt with the waters in the middle, non-navigable tributaries and wetlands adjacent to non-navigable tributaries. And here the court splintered. It was 4-1-4. There was no majority opinion. Justice Scalia wrote on behalf of himself and 3 other justices. And so he wrote what is referred to as the plurality opinion. And he and his fellow justices had a rather narrow view of what constituted waters of the United States. He felt that the only plausible, the only reasonable interpretation of WOTUS would include only those relatively permanent, standing, or continuously flowing bodies of water, such as oceans, rivers, and lakes. And wetlands would only be covered to the extent that there was a continuous surface connection between the wetland and these other bodies of water. And this is an important point because often the focus is there a surface connection or a continuous surface connection? But there's a second part to the Scalia test here with wetlands. And it's that the wetlands are so inseparably bound with this other water that it's difficult to tell where the wetland ends and the other water begins. And I submit to you, it's not difficult to tell in most cases. And if it's not difficult to tell, well, then the wetland's not covered. But we'll come back to that. But a rather narrow view, but it only had 4 votes, and you need 5. In the middle, you had Justice Kennedy. He concurred in the judgment, which meant he voted with the plurality. He voted with Justice Scalia and the other 3 justices, but he disagreed with the plurality's reasoning and also their tone. And Justice Kennedy said, well, wetlands should be jurisdictional under the Clean Water Act if they possess a significant nexus to a traditional navigable water, such that they contribute to the chemical, physical, and biological integrity of these navigable waters. So to recap this first run through the U.S. Supreme Court, you've got total agreement that adjacent wetlands are covered. You have a split decision saying that no, isolated waters are not covered, at least if you're depending on the presence of migratory birds. And then there's a muddle for the waters in between. There's no specific holding, which is difficult then for the agencies. What do the agencies do? Well, what they decide to do is they issue guidance and they say, we're going to follow Justice Kennedy's approach. Even though he was the only one advocating the significant nexus approach, they knew that, well, if the ideological makeup of the court remains the same, and we go with that middle vote, if indeed there is no significant nexus, then that decision of no jurisdiction will be upheld if the case ever reached the court. Or if there is, the assertion of jurisdiction will be upheld if the case ever reaches the court. But also, that depends on the ideological composition of the court remaining the same. So that's what happened after Rapanos. The agencies issued this significant nexus guidance. And so jurisdiction was being decided in many cases on a case-by-case basis. And we'll refer to this as the pre-2015 regime. The regulated entities complained about this for a number of reasons, saying, well, there's uncertainty. We need certainty. Business wants certainty. So the Obama administration in 2015 issued what they termed the Clean Water Rule, which provided certainty, which said that it had some distance-based limitations and requirements, that if a wetland was within a certain distance of other water bodies, that it would be considered to be jurisdictional under the Clean Water Act. If they were beyond a certain distance, they would not be jurisdictional. And then there were other wetlands in between where there would still be a case-by-case determination based on the significant nexus test. So there was certainty, but the regulated community didn't like that type of certainty, challenged it, and ultimately the Clean Water Rule was enjoined and vacated enjoined in most of the country. The Trump administration came in, elected in 2016, came in January of 2017, and in February, the following month, President Trump issued an executive order that called on the EPA and the Corps to conduct a rulemaking to adopt a definition of waters of the United States in line with Justice Scalia's vision, his plurality opinion in Rapanos. Now, I should point out that it is perfectly fine, and indeed it's expected for administrations to adopt different interpretations of a statute. That's a consequence of elections. So there's nothing inherently wrong with a new administration coming in and taking a different approach than a previous administration. But when they do, they have to explain why they're making this change, and it also has to be at least a reasonable interpretation of the law. So Trump administration came in and said, okay, we're going to do a two-step approach. First, we're going to repeal the Clean Water Rule and go back to the pre-2015 regime. And then step two is we're going to adopt a more restrictive definition in line with Justice Scalia's approach. And so that Navigable Waters Protection Rule was issued in 2020. This was a rather restrictive view of the Clean Water Act. So it had no jurisdiction over ephemeral waters, had a much more restrictive definition of adjacent wetlands, and most significantly, it eliminated the significant nexus test. To give you one example of the effect of this rule, St. Mary's University of Minnesota did some modeling, and this shows you the dramatic impacts of the 2020 rule on ephemeral streams out in the arid West. That's where we saw the biggest differences. And this actually comes from an amicus brief that was filed on behalf of the Society of Wetland Scientists. And so there were a number of cases then that were brought by environmental groups against the Navigable Waters Protection Rule. And there were 2 U.S. district courts that found that it was inconsistent with the objective of the Clean Water Act. And so issued an injunction preventing the agencies from applying that rule. So, this is a case where you have some individual district courts saying, well, actually, I'm sorry, let me back up here. The courts, I don't think, you have, I believe there was one court that applied it nationwide, or there may have been some ambiguity about the applicability of the injunction, but the Biden administration decided to treat it as a nationwide injunction and said, okay, for the time being, we're going back to the pre-2015 regime while we conduct our own rulemaking. And so the Biden administration did their own rulemaking, came out with a new WOTUS rule in 2023, which, depending on our poll, 40% of you said, it didn't really make that much of a difference. Actually, 70% of you said there was either only a slight increase and a slight decrease, or no practical difference. So that's sort of 70% in this rather unscientific survey. But the Biden rule has been challenged on a number of fronts, and there have been 2 court decisions against it, one in Texas and one in North Dakota. And so courts there have issued injunctions, and they're not nationwide injunctions, but rather they apply to the states that were involved in challenging the rule. And so currently this new WOTUS rule, the 2023 rule, is only in operation in 24 states. Now, there was another challenge in Kentucky where a U.S. district court rejected Kentucky's attempt to invalidate the rule. And one of the reasons was that the court concluded that there was no standing. And we can get into that in the question and answer period if there's interest. But it's a great quote in this case, saying, basically this is this seems to be a really interesting case. It's important issues. The court would be privileged to resolve it. But judges are not librarians wandering around the reading rooms looking for a topic that catches their fancy. The Constitution limits their reading list, and it limits it to cases or controversies. And so there has to be some specificity in the complaints. And at least in my view, there are some general complaints, but some lack of specificity, and maybe we can talk about that in the question and answer period. Now, also at this time, you have Congress playing a role, and Congress, under the Congressional Review Act, passed a resolution of disapproval of the 2023 WOTUS rule. So anytime there's a major rule issued by an agency, Congress always has the ability to override that rule by enacting a statute. Of course, the president has to sign it, or it has to be overridden, or veto has to be overridden. But what the Congressional Review Act does, it does away with the filibuster. So it's sort of a fast track for a review of agency rules. So both the House and the Senate voted to disapprove the 2023 WOTUS rule. But of course, President Biden vetoed it because it came out of his EPA. So it was really just sort of positioning and political posturing. I would say. And also I note that the intent of this Congress, 2023, tells us nothing about the intent of Congress back in 1972 and 77, where we have waters of the United States and the concept of adjacent wetlands actually being inserted into the law. Meanwhile, all right, let's talk about Sackett, right? Sackett is lurking in the background. And so Sackett Sackett's been around for a while, this up and down to the Supreme Court. This is in Idaho. It's they're seeking to build a house 300 feet from Priest Lake, which is a traditional navigable water. There's not a question about that. There is a shallow subsurface connection between the property, the wetlands on the property, and the lake. Initially, there was a cease and desist order that came from the EPA. The first issue is whether the Sacketts could challenge the jurisdiction, whether there's pre-enforcement challenge, because there wasn't a formal enforcement action brought against them. They didn't want to apply for a permit. It went up to the U.S. Supreme Court. The U.S. Supreme Court said, well, the cease and desist order, this can actually be challenged before you apply for a permit, or even before the agency brings the formal enforcement action. So at this point, then the feds, the EPA, were like, okay, fine, we're not gonna go after you anymore. Have a nice day. The Sacketts, however, were like, oh, not so fast. We'd like a definitive ruling on this, and so the district court said, oh, actually, this is a jurisdictional wetland, and the case is not moot, even though the feds say they're not going to enforce. You could have a new administration coming in, and so the night went up to the Ninth Circuit. Ninth Circuit concluded the same, that the case was not moot, and that technically this is a WOTUS. There's a significant nexus here. So the Supreme Court granted cert. So the Supreme Court then agreed to hear the case, which was a little troubling if you're looking at it from the environmental perspective, because from a sort of a judicial economy perspective, there was no reason for the court to take the case, because there was this mootness issue, but also the Biden administration was doing an ongoing rulemaking at this point. And so typically, at least in the old days, the courts would sort of back off and let the executive branch complete its processes before weighing in. But they took it. They took the case. And the question before the case was whether the Ninth Circuit had applied the proper test for determining whether a wetland is jurisdictional, protected under the Clean Water Act. So the Sacketts took a rather aggressive position. Their opening gambit is that a wetland is not a water. So that's me and my students standing in an area that they would not consider to be water. There were many amici briefs filed on behalf of the Sacketts. So it's the full range of the regulated community, from miners and farmers and businesses, railroads, the National Cattlemen Beefs Association. So all of these groups filed amici briefs. So basically what they're interested in the outcome of the case, or they wish to inform the court about the potential implications of the decision. On the other side, there were fewer filing on behalf of the U.S. Environmental Protection Agency, but included in that group was the brief that we filed on behalf of the scientific societies, 12 scientific societies, including the Society of Wetland Scientists, where we tried to educate the court about the importance of taking science into account in the decision-making process, and also what would be the likely impact of a ruling that constricted Clean Water Act jurisdiction. So if there was, for example, a requirement of a continuous surface connection for a wetland to be jurisdictional, there were models showing that between 20 to 50% of wetlands would no longer be jurisdictional depending on the watershed. But if the court adopted Justice Scalia's difficult to tell requirement, this notion that a wetland can only be protected if it's so inseparably bound with the other water that you can't delineate between the wetland and the stream and the wetland and the river, well, then almost all wetlands would not be covered by the Clean Water Act because it's not difficult to tell, as those of you who practice in this area know. And so we tried to educate the court about that. This was the first case the court heard for its new term, which started in October, first Monday in October. And so my sister, who was on the brief with me, we met in DC and waited in line to attend the oral arguments. These were the first arguments you could attend in person post-COVID. It was also Ketanji Brown Jackson's first day as a justice, and so we were fortunate. We were fortunate to be able to get in. And prior to the argument, we were not feeling very optimistic. After the argument, based on the questioning, we're not sure which way the justices are leaning. A majority of justices, and this is just based on the oral arguments, which, you know, we have to wait for the opinion to come out. But at least based on the oral arguments, a majority of justices accepted that the Clean Water Act regulated at least some wetlands, which they really had to do because Congress specifically references adjacent wetlands in Section 404G, dealing with state assumption. Justices Jackson and Kagan really emphasized the Clean Water Act's water quality objective. And Justice Jackson was also the one justice that keyed in on Sackett's assertion that the wetlands have to be indistinguishable from some other water to be treated as a water of the United States. And so she specifically asked whether the wetlands needed to be visually indistinguishable from a river, stream, or lake to be a WOTUS. Sackett's counsel declined to answer directly. And that, again, is the difficult to tell test that I was referring to earlier. Justice Kavanaugh was very well versed on the regulatory history of WOTUS, and he suggested that the dictionary definition of adjacent is nearby or neighboring, consistent with the agency's interpretation. Sackett is arguing that adjacency requires that the wetlands physically abut or actually touch the other water. So Justice Kavanaugh seemed to be going towards the government's position, although he also stated it should be Congress's job to resolve this issue. Several justices expressed concerns about notice, whether property owners have proper notice about whether their site might be covered by the Clean Water Act. And Justice Gorsuch in particular was pushing for some bright line on adjacency. And he was asking, well, if the federal government can't give us a bright line, how could the property owner who might face criminal penalties for a Clean Water Act violation know? You know, as a practical matter, those of you in the practicing area, you know that there's no criminal penalties brought unless there is a knowing flagrant violation. If I'm wrong about that, please put something in the chats. I'd love to hear some examples of criminal actions brought against wetland violators where it was some innocent mistake and they had no idea or no notice. Chief Justice Roberts, on the one hand, he seemed to be okay if a wetland only had seasonal connections with another water, but he also was concerned that any hydrological connection would be sufficient. So it's a little unclear where he would be. Justices Thomas and Alito, very skeptical of the government's authority to assert jurisdiction in this case. So it's up in the air, and we're waiting. We were waiting this week. We thought maybe the opinion would come out, but it did not. So what might the court do? Well, it's possible, probably unlikely, but it's possible that what the court might do is say, you know what, we shouldn't have taken this case. We're going to dismiss it for being improvidently granted. It's called a dig. And they'll say, yeah, never mind. We're going to allow, we have a new rule that's in place now by the Biden administration. So we're going to allow the litigation for that to go forward. That might be hopeful thinking on my part. So we'll have to see. But that is one possibility. And if there is no majority opinion that comes out, it may be that the court decides they don't want to have another Rapanos type situation, and they might dismiss for improvidently granted, or they might rule on the merits and focus narrowly on wetlands, or just issue a ruling about adjacent wetlands, or they could also issue a ruling that has implications for all types of waters, including non-navigable streams. They could focus on WOTUS more broadly. And, we will hear I expect by the end of June, which path the Supreme Court chooses. Let's assume for the moment that they go with a more restrictive interpretation of Clean Water Act protection. So what are the likely impacts of reduced Clean Water Act coverage? Well, if a water is not a WOTUS, then there's no need for a federal Clean Water Act permit to fill those waters. Even if they were the subject of a previous denial, even if they were the subject of a previous 404C veto by the EPA, if they're not currently a WOTUS, then the property owner is not going to need a permit to discharge into those waters as a general matter. Now, the magnitude of the environmental impacts will depend, because if the feds are no longer regulating, well, then that means that it's the state's responsibility, and not sort of a responsibility under cooperative federalism, but the state's sole responsibility. However, there are many states that tether their programs to the Clean Water Act. And so as federal jurisdiction contracts, so may state jurisdiction. And even if a state wants to take over responsibility for protecting these waters that the feds had done previously, it'll take time. It'll take time and money to develop these regulatory programs. It actually took California 10 years to fully implement a response to SWANK that was issued in 2001. Now, if a water is non-jurisdictional, that also means that there is not going to be any need for a Section 401 state water quality certification. So if you think, oh, well, okay, the feds back out, but there's always the state acting under 401. No, 401 only applies if you've got this federal action that's going to result in a discharge. And if there's no federal permit, well, then there's no federal action, thus no need for a 401 state water quality certification. For those of you in the mitigation business, this also has implications for you, because obviously the concept of mitigation banking as an industry is dependent on the driver, which is the requirement that a permittee provide compensatory mitigation. And so if there's no need for a Clean Water Act permit, that means there's no need for these projects to provide any compensatory mitigation, and thus no need to purchase mitigation credits from a mitigation banker. One complication for developers, however, would be that if there's no need for a Clean Water Act permit, that means that then there's no need for no hook for a Section 7 Endangered Species Act consultation if there happens to be endangered species on the property. But that doesn't get you off the hook if you're a developer. It just means Section 7 doesn't apply, but then it kicks you over into the Section 10 incidental take permit process, which doesn't have as tight timelines or timeframes as the Section 7 consultation process. So if you've got a parcel that has wetlands and endangered species, if a Clean Water Act permit is not required, it actually might take longer to develop that piece of property, as we saw after the Swank decision. When some isolated waters were no longer being regulated under the Clean Water Act, there were developers who were coming into the Corps saying, hey, please assert jurisdiction so we can fall under Section 7. And the Corps was like, sorry. But on the whole, obviously, if jurisdiction is constricted, the development community and the regulated entities will be rather pleased. Environmental community, not so much. So I'll end there and look forward to your questions and the discussion. Thank you very much.
Well, thank you, Roy, for that great presentation. Let's get some of the Q&A. There's been some very interesting items in the chat really already, trying to answer some of the comments that you made. But let's go to the Q&A area. Allison Keller asks, what if USACE/EPA gives contradicting guidance?
So ideally they would not, but ultimately the EPA has the call on waters of the United States, at least according to an attorney general's opinion, the Civiletti opinion back in the day. And the reasoning behind that opinion was that the EPA has the most responsibility, the broadest responsibility for the act. The Corps has, a piece. An important piece, to be sure, but if there was a dispute between the two agencies, ultimately, I believe EPA would have the ultimate authority to make the call.
Right. I would think that if you have that perception that the Corps is not correctly representing what they've been instructed to do, because the EPA is who instructs the Corps how to do things a lot of the time, right? I mean,
well, it should be. It's a collaborative rulemaking process,
right.
but ultimately, it's the EPA.
Yeah. Okay. We have a question from Tyson Kurtz. He says he's looking for further explanation of non-jurisdictional waters. Is there a timeline or explanation for, quote, excavation operation is abandoned and the resulting body of water meets definition of WOTUS? Is abandoned mean a certain number of years, X years? How would it revert to meet the WOTUS definition if it was created in dry land, in the beginning?
That's a good question, and I can't answer that specific issue. And under which rule are you talking about? I suppose as well. That would be important to know.
That's true.
But it's there. If your permitting agency is the Corps, well, then you have to take a look at the Corps guidance, right? So the regulation itself isn't going to tell you how many years. So then you have to see whether there's any additional guidance or whether it's relying on the discretion or the best professional judgment of the regulators.
Okay. Our next question comes from Greg Snowden. He asked, Professor Gardner, looking into your crystal ball, how do you think SCOTUS will rule on the Sackett case based upon the oral arguments? I know you gave us a little taste of that. Do you have anything you would like to add?
You know, maybe if they do reach the merits, perhaps they'll just come out and say, in this particular case, it is close enough to be considered adjacent, and then move on. But they might take the opportunity to say, well, this is adjacent, and then further provide guidance on whether the significant nexus approach should be used or not. But you know, really have no idea how the court's going to rule on this.
Our next question, let's see if I'll go ahead and read it. If Supreme Court rules broadly on WOTUS, what happens to the 2023 rule? Does it need to be revised again? Or
yeah,
it
unfortunately,
seems like it's kind of a mess with these other court injunctions going on.
yes, it is complicated, and so if and when the Supreme Court rules on this, it could definitely have an effect on the 2023 rule. So, for example, if the court says that a significant nexus test is not the right approach to use, that would then call into question the continuing validity of the 2023 rule, and there would have to be some revisions. I mean, one thing to keep in mind, of course, you know, is that ultimately Congress could resolve this. It's a statutory term. So if there was will in Congress aligned with the president, this could be resolved, although obviously, considering the current political situation, that is unlikely to happen.
Our next question has to do with Florida state assumption. It asks, how about the FDEP 404 assumption in Florida? Will FDEP adopt any changes to the WOTUS definition? Can you share any insights into what's going on in Florida right now?
Yeah, so I'm currently in Florida right now, and so, and I just have to, no, I'm not gonna, well, everybody was awoken at 4:45 in the morning with an Amber Alert. Speaking of interruptions, but there was a mistake by the state sending out a test Amber Alert this morning. So everybody's grumpy in the state of Florida. But responding to the question about what is going on in the state of Florida with assumption. So as most folks probably know, the Clean Water Act allows states to assume the federal permitting programs, and most states have assumed the 402 program. Very few states have assumed the 404 program. So only New Jersey, Minnesota, and Florida in the waning days of the Trump administration assumed responsibility for issuing Section 404 permits. When the Biden administration announced that it was going back to the pre-2015 regime, the state of Florida said, we're gonna stick with the navigable waters protection rule, and there's a dispute now between EPA and the state over that. I do have to say, I think the state has a good faith argument here, because under the assumption rules, when EPA changes a rule, that the state is given 1 year to come into consistency with that change, which only makes sense. You have to give states that have assumed the program some time to actually adapt their program to become consistent with a new federal rule. And so it was a little unusual where you had judicial action that was affecting the status of a rule. But now that you have the Biden rule, the 2023 rule in force, you might think the clock has started to tick. Although now that it's enjoined, I'm not sure. So in any event, it's a complicated situation in Florida.
All right. Well, thank you. I think that's all the time we have for questions. If you forget to ask a question or need to leave, you can email the presenter at the email address listed on this slide. And any unanswered questions that we might have will be sent to Professor Gardner, and a follow-up email addressing the answers will be sent to the attendees. So thank you, Professor Gardner. If we could move on to the next slide. We're proud to recognize our SWS webinar series sponsors for 2023, BioApp, Cattails Environmental, Davey Mitigation, and Ducks Unlimited. You can find their information at the websites listed above. Please visit, like, and follow our SWS webinar sponsors. Our next English language webinar will be May 18th on the development and implementation of an agricultural wetlands mitigation bank. And on June 22nd, we will be joining Dr. Angel Alberto Alfonso Martinez for a Spanish language webinar. Check out our website and social media channels to learn more and register for upcoming events. And don't forget to complete the survey that will be sent to you after this webinar to receive a certificate of participation and provide feedback to the planning committee on this webinar series. Thanks again to Professor Gardner and to our audience for participating. Everyone have a wonderful day.
Thanks.